efforts to address gun crime in Chicago through legislative action. And it was certainly the center of SPAC's world for many years. But in 2017, the Safe Neighborhood Reform Act was actually passed. It was the culmination of about 4 years of negotiating and not getting bills to votes, and SPAC doing analysis after analysis after analysis, because the concern was that we would blow up the DOC population if we had significant changes to gun crimes, unlawful use of weapons, specific crimes for aggravated unlawful use and UUW felony. So the Safe Neighborhoods Act was the ultimate resolution, and it did, I am very broad stroking this, but it increased the minimum for aggravated UUW and UUW felon for a specific group, repeat offenders with specific predicate felonies in their histories. One of those prior felonies was UUW, of course. This is one of many types of analysis that we did. Kwame was on SPAC at the time, and this was the first time that we really engaged with a lot of analysis. The other thing the bill did, provided a safety valve for judges to depart downward if specific criteria were met. It created the first-time weapons offender program to divert young first-time offenders from the prison system, and unique to criminal laws, has sunset provision. It sunsets at the end of this year. And also had another unique provision, which was that SPAC would be required to produce a report and report on some basic numbers, but also trends in sentencing. So concern were twofold. One, controlled population impact. Two, have some response to gun violence. So unlike previous bills, which have been a trifecta of increased mandatory minimums, eliminating probation, and applying 85% truth in sentencing, this bill was designed to not do some of those population driving things. So in 2016, the negotiations began, gun bill fatigue had set in, and gun violence was continuing. So 2016, we also saw, we didn't get a bill in 2016, but we had a lot of emails back and forth. We saw Governor Runner get elected. He created a commission on crime and sentencing with the goal of reducing the prison population by 25%. And he had a public safety director who joined with Kwame to negotiate this bill. The city of Chicago, the Chicago Police Department wanted the term mandatory minimum. That was their buzzword that showed they were responding. And Superintendent Johnson came to Springfield repeatedly and made repeated public statements that if we pass these harsher penalties, gun crimes would be reduced by 50%, which is a nonsensical and non-factual assertion. Years and years of research, which you all have heard in various contexts, have established that harsher penalties do not act as a general deterrent to crime. So we did things like looking at sentences and predicates, because he wanted to get to a predicate list that would address people who were the most likely to become violent offenders. Next slide, John.
Here.
We did population impacts, trying to find that balance point. At one point, there were drug penalty changes in the bill that balanced out the likelihood that we would see an increase in the prison population from the UUWs. And we did, the basic felony convictions over time. Prior to this, in years prior, we had done a study on the impact of sentence enhancements on gun and violent crime, and found that we saw no discernible impact in terms of crime rates. We saw a measurable impact on the prison population, which increased, I think it was about 3,000 people at that time. So that was the kind of context of the negotiations. The advocacy community was dead set against mandatory minimums. There was and some of the legislators had a blanket policy of not of not supporting them. And they were successful in pulling some Democrats off of the bill with that argument. So we had a bipartisan negotiation going on. We had intense advocacy on both sides. The Democrats were responding to the advocates. The Republicans were responding to the Bronner's direction to reduce the prison population, but not be soft on crime. And the final showdown came in the House committee. Kwame got the bill out of the Senate, and it became truly bipartisan when Leader Jim Durkin picked it up in the House. And at that point, I think Paula will be able to correct me if I'm wrong, the first-time weapon offender program was added to the bill. So we had a diversion program for young first-time weapons offenders. Again, population impact would be to keep people out of the population. The goal, and we're going to talk about this more in depth in a little bit, was to have an avenue whereby if they completed the probation, they would not have a criminal conviction on their record. So in that hearing, there was a lot of back and forth, a lot of insistence that the DOC population would be exploding, that there would be an across-the-board negative impact because having harsher penalties for this specific target group would lead to harsher penalties overall. And there was a SPAC analysis that indicated that the population impact with the amendments that had been made would most likely be neutral. So the bill got out of committee and it passed, and that was the one and only time I had two Democratic members coming out of committee share their view that SPAC was despicable because our analysis had not supported the argument that they very, very strongly believed in. But this was certainly one instance where, you know, the numbers and the research came up against really strong feelings, really strong emotions, a very serious problem with gun crime. But by providing the type of analysis that Kwame needed at that point, we were able to help him target the harsher penalty and limit the number of people who would be ending up going to prison for a longer term. So that's kind of the historic context of all of that. And now we are at the end of December. Well, we're at the beginning of December of 2022. The bill sunsets on January 1, and we're completing our final report. So we wanted to share with you what we found when we looked at the data around sentencing for people who were subject to the presumptive minimum. John is our primary researcher on that, John Specker, who will go over that. And then Abigail Drum, our newest team member, is the person who did the deep dive into the first-time weapons offender. And we discovered some interesting things there. So John, take it away.
Thank you. Okay, so as Kathy said, Safe Neighborhoods Reform Act did create a new presumptive minimum for individuals who had qualifying predicate convictions. So the idea of this act was to focus only on those individuals who had one of the 26 qualifying predicate convictions. Those qualifying predicate convictions are a combination of other gun offenses, other violent offenses, or other offenses that are deemed violent. So examples of this is UW felon, home invasion, things of that nature, murder, obviously. So those are kind of the qualifying predicate offenses that will put somebody into that eligibility for either a conviction for an ag UW, which would be a 6-year minimum sentence, and UW felon, where there would be a 7-year minimum sentence. So the difference between aggravated UW and UW felon is aggravated UW is typically when you have a firearm, it's loaded and it's accessible. So you have a loaded gun and it's ready to use. UW felon is more broad in terms of you have a weapon, but you are a felon. So basically, UW felon is any UW offense as long as you have been previously convicted of a felony. So that's the difference between those two. And then within the act, or within the Safe Neighborhoods Reform Act, there was downward departures were allowed if the judge felt it was necessary in the interest of justice. And based on the factors. And based on the factors of the cases, right? So
That's in front of you on that sheet.
Yes. Yeah. So in front of you on the seat on your table, you will see the sentencing order that SPAC created to try to quantify and understand how often are these downward departures happening, what are the reasons for these downward departures, and what are the qualifying predicate offenses that led to an individual being eligible to be sentenced under these circumstances. So SPAC developed this in 2020. It was approved by the Conference of Chief Judges and then went to the clerks to then went out to the clerks for them to provide this information via email to SPAC. Unfortunately, as most new things within government, it didn't get picked up too quickly. So SPAC worked with the AOIC, and they were very helpful in trying to push out reminders about sending orders to SPAC about Kate. And then as those reminders went out and out, we got some more trickling in, but there were still clearly an undercount in the number of forms SPAC received compared to the universe of downward departures that we were seeing in the criminal history data. So with this, SPAC worked with the AOIC to create a case number list. So case numbers that we saw an individual who had the predicate offense and received a sentence below the presumptive minimum under the act. So we worked with AOIC to work with the clerks to send those case numbers out to see if there were UW forms or sentencing orders for these cases. Unfortunately, we still have not received, we've only received a tiny fraction of the number of sentencing orders that we expected to see. So we do not have any reliable takeaways from these forms. I believe at this point we've received about 60, give or take, 60 forms, and we have about a few thousand people that have had the downward departure. So obviously the forms need to keep going to get that traction, right? Government moves slow, we'll get them soon. So before I go into the findings of a report, I just want to give a universe of what's going on with UW offenses in the last, since 2001, and kind of give a universe of what have we seen since the act was passed. So as you can see on this chart, we have aggravated UW and UW felon arrests broken out by if that case had a prior predicate conviction, if the individual had a prior predicate. As you can see on this chart, most people who are arrested for UW do not have a prior predicate conviction, right? They don't have that prior predicate that's going to put them into that presumptive minimum. And we can also see that relative from 2000 to 2016, UW arrests were relatively stable, right? They didn't change that much. They were just a relatively consistent amount. But in 2016, overall arrests for aggravated UW or UW felon increased by 82%. And that was at the same time that overall arrests decreased by 40%, right? So we're seeing these two UW offenses increasing dramatically while total arrests of felonies are decreasing dramatically. So, and then the other thing that's very noticeable on this chart is a 175% increase in the number of aggravated UWs with no prior predicate conviction. So there is clearly something going on with Ag UW, whether that's charging decisions by police, whether that's or arrest decision by police, charging decisions by state's attorneys. There is an dramatic increase in the number of aggravated UW arrests that we are seeing. And that is largely what's driving the overall increase, that overall 82% increase in arrests for these two types. So as we go to this side, we have our convictions, right? So convictions are a little less stable than our arrests, right? They're a little bit all over the place. We do have 2020 where court closures impacted heavily the number of convictions and dispositions we saw. But as you can see here, aggravated UW has quite a few convictions. The issue that we've discovered through the process is those convictions may not be extremely reliable. We'll get into that a little bit with Abigail's presentation a little bit later that talks about how convictions are recorded for the first time weapon offender program. But as you can see, we do have an increase in the number of convictions for these offenses. But again, with the aggravated UW, there are some underlying issues that may be causing some of the driving factors. So here we have admissions to the Illinois Department of Corrections. Admissions for the, as you can see, admissions are increasing for both aggravated UW and UW felon. And something that's important to note is UW felon admissions are a higher percent of UW admissions to DOC. This is likely because it's non-probationable. UW felon is a non-probationable offense. As a percent of admissions, aggravated in fiscal year 22, UW admissions accounted for 22%. Aggravated UW or UW felon admissions accounted for 22% of total admissions to DOC. That is up from about 5% of admissions in state fiscal year 16. Obviously, that's a result of the overall number of admissions decreasing for things like retail theft, things like the lower level crimes that have been diverted from the system, but also you do see an increase in the aggregate number of UW felon and aggravated UW admissions to DOC. Just a little bit more information on the on the current population. 7% of the overall population on June 30th, 2022 had an offense, holding offense of aggravated UW or UW felon. That is up from 4% of the overall population on June 16th, June 30th, 2016. So as you can see, UW is growing in the prison population. It is becoming a larger focus, larger emphasis of our system. So with all of that in mind, we wanted to look at and see what did the Safe Neighborhoods Act do? Was the Safe Neighborhoods Act responsible for this? Were there other factors? So for our research questions, we set out to answer these three main research questions. Was there an increase in sentencing at the new presumptive minimum for those with a predicate conviction? Is there any change for those without a predicate conviction, right? So the intention of the bill was to focus only on individuals who had that prior criminal history and not impact those without. Did the bill have the intended effect of that? And then did changes make sense given the timing of the arrest and sentencing? So for this bill, it went into effect on January 1st, 2018. So any arrest that occurred before that should not have been sentenced under this act. So we made sure that there was no kind of trend in the harsher sentences or in the presumptive minimum sentence for that intermediate period of people who were arrested prior to that act, but sentenced after it. So we were able to isolate the effect of just those individuals who were arrested and sentenced after the effective date of the act. So we came about these analyses in a couple different ways. We did descriptive statistics about the percent of people who were sentenced with a prior predicate conviction before and after the act to that either 6-year sentence, 6 or longer sentence for aggravated UW, or 7 or longer sentence for UW felon. We found that the overall percentage of individuals sentenced at or above the minimum did shift for those people with a prior predicate offense. And we also found it's the building.
Your Google business listing has not been claimed or verified. Press 1 to be connected to an agent. Press 2 to be placed on our do not call list.
2?
Let's do 2.
Yeah. Okay. So I'll just keep going. So we found that the number of people sentenced with a predicate conviction, the percent of people who were sentenced post-act did increase. We also found that it was relatively stable for those without the prior predicate conviction. So that made us a little bit more comfortable that, okay, there wasn't something going on with both groups. But with descriptive statistics, you can't really control for anything. So we did got ahead of myself. The average sentences for these people who were sentenced for UW the typical individual was a black male from Cook County. The distribution of people from Cook County, the vast majority of people who were admitted for aggravated UW were black males from Cook County, but for UW felon, while they were still a large proportion of the number of sentences for UW felon, there was a more evenly dispersed distribution, more evenly distributed admissions from Cook County and non-Cook County. The average UW felon individual was on average a little bit older and had a more lengthy criminal history compared to aggravated UW. And the most common prior predicate convictions for these individuals were another aggravated UW or UW felon offense. So I talked about the descriptive statistics. So in order to kind of isolate and control for other factors, isolate the effect of being sentenced post-act and the factors that may also lead to what type of sentence was imposed, such as criminal history, demographics, sentencing county, things of that nature. We ran a regression model. We ran a binary logistic regression model to control for all those factors. And we found that individuals who were sentenced post-act and had the prior predicate conviction were 2 times as likely to be sentenced to a term at or above the presumptive minimum sentence. And we also found that there was no statistically significant or substantive difference in the sentence length for individuals without the prior predicate conviction. So what does all that mean? That means individuals who had the prior predicate and were arrested and sentenced after the act saw an increase in sentence length, but individuals who did not have a prior predicate who were arrested and sentenced after the act did not see an increase. So the targeting of the language of the bill and the targeting of the negotiations seems to have been effective in not impacting those individuals who were not intended to be impacted or avoiding those unintended consequences. Any questions on any of the presumptive minimum?
We have 2 people in the chat.
Those
That's That's old, they're
No,
not.
is it? Okay.
Okay, so as I tease the, yes.
So you talked before about the difficulty of getting data. What are your conclusions based on how much data do you have?
So the data that we have for the data set that we used to ensure that we did not have any issues with sentences or anything like that, we used the Illinois Department of Corrections case management system to examine all sentences for UW or UW felon or aggravated UW. That way we had the all-encompassing sentence universe to DOC. So we were confident in the sentences that we had and the sentence length. Yes.
Sentences that is there any way that you can tell from the data that you had which of these sentences were arrived at? The judge actually having the decision about whether or not to stack an aggravator on top of an aggravator or something.
Yeah.
To get to that higher.
So we cannot identify whether there is a guilty plea or a bench trial or a jury trial in our data. We just have the the offense and the sentence length in our data. So we are unfortunately not able to isolate that. But there was a good report about plea bargaining put out by Safety and Justice Challenge very recently that focused on St. Louis and Milwaukee that has a little bit of information. But that is something that in a perfect world, we would be able to get a little bit more information around that, because it would be very important to know, is the sentencing happen because of charging decisions and state's attorneys imposing it, or is it coming from the judges in that perspective? So what is going on there? Yeah.
And we're at a time coming through, assuming, I don't know if we have data of disposition for black guy being guilty over the past 2 years versus what the standard number of 20%, which is always up behind.
Yeah, correct. Yeah. So that is something that would be very interesting to be able to examine, but unfortunately with the data limitations that we currently have, we do not
We
have
might,
access to that.
we might be able to link up clerk data to it. I don't think we would have it for every county that way, but we could take a look.
So just make it clear that this category, this first paragraph indicating that the people with prior predicate convictions, they were sentenced to longer sentences. And so that would result, I'm trying to go back to your previous chart showing the increase in the prison population. That would reflect an increase in the prison population, correct?
So
Or the terms are longer, so.
longer sentences, yes, you would have an increase in the number of people and the length of time they're serving. So we can't really isolate the effect on the overall, we didn't really isolate the effect on the overall prison population. We didn't run a projection for this specific example, but yes, as you increase sentence length, and we also saw that the number of people who were sentenced under these offenses was increasing. So as you increase both of those, you will be increasing the prison population as well.
So with the people who initially proposed the change in the law, they would look at this and they'd say it worked.
I think that is a great question for the Attorney General. I don't know that I can.
All right, Christelle, it's your first meeting.
I don't know that I can. I don't know. I wasn't around for the legislative intent, but I think Kathy may be able to answer that a little bit more. But yes, but yes.
Go ahead, finish it.
No, go ahead.
I was just gonna ask what the average underlying sentence was before and after the law went into effect. How many more years are we talking about in the average sentence?
So that's actually something that is relatively interesting. The average sentence overall did not change all that much. There was an increase by, I think, about half a year for UW felon. But what we saw was the number of people sentenced right at the presumptive minimum increased, but also the number of people sentenced at the low end of the range increased as well. So like you kind of saw, like, if we're giving someone this presumptive sentence of 7 years or 6 years, but then when the judge would downward depart, they would downward depart beyond what they previously would sentence. You would sentence in that range, but the number of sentences at that minimum range increased as well. So it kind of like bifurcated the distribution a little bit.
It's more apparent, I think the average change is apparent in UW felon. The average UW where you get those lower sentences is it doesn't even look like it's much of a difference.
Yeah, So the average, so like that is something that the average sentence didn't change all that much, but the number of people sentenced at or above that range increased. So you kind of have that, I'm sentencing at this minimum, or I'm sentencing at the statutory minimum for the class.
I'm gonna just jump in here and plant a little seed, because we're gonna be talking about qualitative research at the end of the meeting. And that's kind of a question, why, how, we don't really have the ability to answer those questions.
I'm monitoring the chat.
With doing just the statistical analysis. And I will also add really quickly, there was a data collection provision in the bill. But as Dan Hunt can tell you, you don't screw with the clerks. And they came down hard on getting that out of there, and so it came out. So that's that's always part of our issues. Sorry, John, for the interruption.
Can you just go back to the previous chart showing the increase in UUW?
Admissions, this one?
These are admissions, so these are the major increase in, is it a major increase in sentencing? It appears to be. What did you say the percentage was of in the prison population of UUWs?
So overall, the percent of individuals in DOC for UW was, I think, 7% on June 30th, 2022. And then previously on June 30th, 2016, it was 4% of the population. But that also, while the aggregate number of people who are in prison for UW increased, there were also significant population changes in that time frame between retail theft changes in sentencing decisions, and changes in kind of charging decisions.
So a reduction in the population for those other crimes, but in the case of UW, an increase.
Correct.
Over the since pandemic.
Yes. Yeah. And also I'm still unclear on how smoothly the courts are going through the backlog, especially with UW cases. So in 2022 through June, we do see a relatively large number of convictions for UW. So it's very likely that convictions and admissions in the next fiscal year in fiscal year 2023 will be higher than 2022. And that's kind of driven by, as you can see, our arrest slide here. Obviously, as arrests go up, it takes time for those cases to matriculate through the system. So we will likely see another substantial increase in the number of admissions.
Are there more guns? Are there more? Why are there so more arrests?
There was definitely an increase in gun purchases during the pandemic. I
Yes.
think it might have been actually at an all-time high.
We did, we looked at this across the state, and I mean, the large increase is Cook County.
Yes.
Right? Almost all of that within Chicago. And it's we see it largely as a change in enforcement practices.
Yeah.
That law enforcement went out to target illegal gun possession more after the spike in homicide in 2015, 16.
Yeah.
That this was an effort within the city to try to.
Because I don't have the data to back it up, but I would think that rising gun purchases would not account for that, because those are folks who are going to get their boy card, and if they do have a weapon, most of those people are doing that. They have a weapon. That would be my thought process. So that increase enforcement probably something that leads to that more so.
I do know in the
So these guys didn't purchase their guns at the gun store.
Oh, yeah.
John's point, there were more guns in circulation over the last 4 or 5 years, right? So, well.
Increase in
they were
stolen
being
firearms.
purchased perhaps outside of Chicago and brought here from Indiana illegally.
And there's a traffic stop task force for IGC. It's not related to this, but there is I think it shows a huge increase in traffic stops. I would be curious to know.
Yeah.
Is there any data to the point about the availability of guns? You know, I mean, I've just in conversations I've had anecdotally reports from judges, you know, that the availability of guns in the neighborhoods to kids and others has, you know, increased drastically. But, and I haven't looked at any data. Is there any data out there to, you know, to correlate, are the roulette, you know, obviously the pressure on law enforcement because of violence and homicides in 2016, recent years, drives their traffic stops to, you know, try and intercept guns. But is there any data out there that can correlate, you know, the availability of the streets, you know, indicate whether that is a crime? Does that make sense?
Yeah. That's a great question. I do not have the answer off the top of my head. Did the crime lab do anything on that?
I think the way that it's typically measured, because of restrictions on data sharing with firearms, is that the way I think people try to measure it is to look at how many background checks go to the FBI to purchase a weapon. In terms of the actual availability of guns in a certain community, I don't know if I've really seen anything like that. I would think maybe they would have to get that through some sort of survey research, but I don't think I've seen anything like that.
That would be a great spot for qualitative stuff.
I will say, similar for probation and community corrections, that is widely held belief that they believe that there are simply more guns than there were. But again, not based on research, it's based on their seeing here.
I just take comments from judges and judges. It's easier to get a gun than it is a piece of
Then what?
than a piece of fruit someday.
During our last SPAC meeting, we had that panel of incarcerated people who were there for gun offenses.
Right.
And we talked about how easy it was to get a gun, and it was like nothing to them. They didn't even consider it to be difficult.
There's no gun deserts.
Right.
We put
with the AG's new system, the new tracing system that the AG just implemented through state police, I think that will start providing data as well. As far as all these departments are participating, the system's just been rolled out to help with tracing for strong purposes, things to that effect. So it just this past year just went into effect. So that should also start providing some data as well.
I assume that's all the questions for me. Okay, awesome. Well, as I teased from this slide, there are some, with aggravated UW, we found some inconsistency with how the convictions were recorded. So I will pass it off to Abigail to give us some information about the first-time weapons offender program.
Well, Abby gets set up. Mike just handed me a note that indicated that the Safe Neighborhoods Act sunset has been extended for a year as of yesterday. So we are still in business.
That's a relevant.
A relevant fact. You know, those legislators, when they put their mind to it, John, they can really get stuff.
Yeah, I made a few calls.
Alright, so so as part of the Safe Neighborhoods Reform Act, it included the first time weapon offender program, which does not want to let me click to the next slide. There we go. Okay, so it was created as an alternative to incarceration for young first time offenders. A main point is that it does not result in a conviction because the legislature recognized that having any kind of a gun felony offense on a record for the rest of your life can have very serious consequences, as I'm sure you all are aware. So the eligibility for the program was 18 to 20-year-olds charged with specific UUW, and that includes certain ag UUW. It's any misdemeanors, which is the only misdemeanor you can have, and that's UUW, or ag UUW for class 4 felonies is the eligibility. They have to have no prior convictions, either adult or juvenile, for a violent crime, and the violent crime is specifically defined in the statute. And then no existing protection order issued against them as well. The way it works is the defendant pleads guilty, there's not a judgment entered, and upon the successful completion, the defendant is discharged and the charges are dismissed. That is the language of the statute. So there was no required data collection for this either. There was a CRI code created for a disposition of the first time weapon offender program. It does not show up very often at all. And so we were asking the question, okay, what can we look at? Since we don't really have that much of this, what can we look at? So we decided to try to identify the target population of who would qualify and met all the eligibility criteria. Because of some data limitations, mostly we don't have all of the relevant juvenile convictions or any protection order information. We couldn't account for all of the factors, so the number of the target population that's included is probably an overestimate, but we did everything we could to try to account for those. And the other thing that you'll find is we used, instead of convictions, we're using the term guilty dispositions, because it does include convictions, but it also includes any kind of withheld judgment, specifically, importantly, the first time weapon offender program. So it's not a conviction, so that's why we don't, usually we use the word convictions in our analysis, but that is why that's not happening with this. So this is the differences. So this is, you've got Cook County and non-Cook County, because as was referenced earlier, almost all of this is in the increase has been in Cook County. So you can see this is just comparing incarceration, which is DOC or jail, almost always DOC, versus non-incarceration, which is primarily probation. There, you can see over time, not everywhere, not Cook County has stayed rather steady in terms of they, even before, did not tend to sentence people who would qualify. And this is in opposition to the idea is this is anybody who definitely doesn't have a predicate because they do not have any kind of a violent offense. These are young people. But in Cook County, you can see starting in 2018, there's a switch to including having more non-incarceration sentences then sentencing to DOC. And the 2022 is through the end of August that we have that data. So it does coincide with the implementation, which started at the beginning of 2018 with the first time weapon offender program in terms of Cook County's change towards more non-incarceration sentences. So here are, this map has two important factors on it. The first one is just the total number of guilty dispositions for the target population we identified since 2018, which is when the act went into effect. You will notice that Cook County is about 2,100 versus the next highest county is about 50. So there really is, it very much is a concentrated crime being charged. However, and then highlighted ones are ones that have any first-time weapon offender program cases that showed up in our TRI data. There weren't many, but as you can see, the ones that are there are from all over the state. So this is not just something that's been used in Cook County. It has been used by, all up and down the state. Different prosecutors have chosen to use this program. So I think that's important as well, because we're going to talk about Cook County in a minute here, but I mean, it's important to know that, yes, it is being used, and it's being used all over the state. Okay, so as we showed you earlier, there was that switch between 2018, where Cook County went to more non-incarceration sentences, primarily probation. So we had found that there were public statements from the state's attorney's office, Cook County State's Attorney's Office, that they were using this program. They had told us this as well. So we did not see that in the data at all. There were only 13 cases that were identified as the first-time weapon offender program out of 2,100. So that really raised a flag with us, saying this doesn't make any sense. So what we were able to do is we did a manual view of a small random sample of cases that appeared eligible, but had a conviction instead of that disposition for the withheld judgment under the first-time weapon offender program. And what we found is that the majority of them had the first-time weapon offender program as the sentence. And a few of them specifically indicated that the judgment should not be entered. However, in our data, which is the official state's data used for state background checks, did not have that. It had convictions for all of those people. So we were, however, able to get the Cook County Probation's Office does keep track, because they're the ones that have been running the program. They do keep track of which ones are this type of case. And so they were able to identify those for us and give us a per year percentage of, or numbers for intake cases. So and that's compared here to per year to the target population. Once again, I'll remind you that it's definitely an overestimate. So what this says is even Cook County that is using it, wrong with the data, but they are using it. They're using it at a fairly high rate for those who could qualify. So that is, Kathy, should I ask questions? Should I take questions now, or should you talk and then we do questions?
Well, does anybody have questions? Then I'll kind of wrap it up.
Yeah.
Yeah, I have a question. So am I understanding you correctly that these individuals think that they don't have a criminal history because they were first time weapons offenders?
Yes.
But they actually do have a criminal history.
According to the official state records, yes.
Well, that's a big deal, right?
Yes.
That is a big deal.
That's not good.
No.
So let's talk a little bit about what happened when we found it. So we weren't the first to find it. The Cook County Public Defender's Office had a bead on this issue, but we found out that there were some ongoing discussions amongst the Cook County crew. But in our experience, one of the key components of any data set is the AOIC codes. And so we wanted to bring in the AOIC and had a meeting with the clerk's office and the AOIC to talk about what was happening. And you know, here's the fly in every ointment. When it comes to implementing the policy, it's a good policy. We all liked it. We think we are tracking what's happening in these cases, and we are in terms of docket entries, perhaps. But the coding on the coding in the systems is not. They're not speaking to each other. They're not translating. And you know, unlike most other counties, you know, Cook has different ways of reporting into the CRI system. So there was a consensus immediately that what you just described is a bit of a problem. The clerk's office has been very cooperative in providing information and responding to us when we've asked for additional information or permission to look at data. We have put out to them, you know, what our understanding of the issue is, and we have had a couple of different discussions about what the solution would be. And the stakeholders you can see, pretty much those who have a feed into or a responsibility in maintaining data. Most recently, Mary, we did reach out to John Thompson at ISP. So there's a commitment to fixing this problem. The question is, how does it get fixed? And it is a systems question. There has to be a change in how the data is coded in the clerk system. There's also an issue with judges having to be clear in the courtroom that a judgment is withheld. We want to make it clear that this is not a problem that is generated by the new clerk, Clerk Martinez. It exists prior to her taking office, and it also exists with other forms of probation. So it's a bad problem to have. It's illustrious from our perspective of the benefit to having use of data and more eyes on the data. So, you know, we're hoping, Dan, you might have insight into this, that the turnaround on the coding issue is going to be more speedy than might otherwise be because of the really significant impact on individuals who did what they were supposed to do. And, you know, judges recognize that, but record keeping is record keeping. So
Kathy, it doesn't sound like it's intentional.
It's not intentional.
And you have more detail on how it actually works. I used to be a public defender. You think the lawyer representing the defendant would say, hey, we got
Yeah, there's a problem here.
right? But who is it that enters?
How does it flow from that decision?
I mean, nobody's doing anything intentionally wrong, but who's missing the
Correct.
line, I guess.
I'll give the overview, Abby, and you can jump in.
I mean, I can-
Gaps, and
yeah,
Dan,
okay.
you may have some gaps.
How does
that
it
you
work?
fill in as
How does
well.
it work so there's?
So
Yes,
in
now-
the courtroom, the judge fills out a court sheet, which records the sentencing decision.
That is a written order. There's
Right.
nothing
It's
digital about
handwritten,
this.
Not digitized.
There is a large variety in how much or what gets written down.
Yes, and that's nothing new.
Yeah.
We've known that about judges for a long time. So the clerk then records in the system what
The judge said.
what the judge said, but some of the clerks didn't understand that this program, and I'm sure that every attorney and judge in the room understood because they are used to it, that this is, you know, FTWOP means withheld judgment. The clerks did not have that understanding. They have,
They did create a code for it. They created a sentencing code.
right, but that's not the clerk in the courtroom,
Yes, the clerk in the courtroom enters that. They do enter that code.
I guess.
Okay, you're saying, like, the thing is, the clerks in the place, they are entering correctly what they have been told to enter.
Right, so.
The issue is outside of that.
The transition.
After
Yep.
they enter, what happens next?
Then the clerk system and the automatic disposition system interact. And that's where the translation is not correct, because in the AOIC, I may get this wrong, so correct me, there's sentencing and dispositions. In the clerk system, it's a disposition and it should be a sentence.
Other way around.
Other way around. So basically, they're characterized differently in the two systems, but the ADR system is what feeds into crime. So we all have, I think, a clear understanding of what the problem is. The question now is how do we solve it? And I think the ALC is probably directly involved in that now with the clerk's office, and everybody's working on it.
And do we know if there's any defendants who later on got arrested?
Yes, there was one case that we found that the fellow completed the probation and he got arrested again.
For a second offense.
Had a gun in his possession, so he was a felon with a gun with a predicate in his history that he shouldn't have had, and now is subject to the new mandatory minimum. But I trust that the PD's office is handling that one directly. We will talk with Shrub about that just to make sure it's on their radar. So real life, you know, Dana's like up here in the clouds for most people, but has real life implications.
So if I got, this probably beyond the scope of what I'm listening to, scope just from my own education. Do we look at, is the program simply successfully completing a probationary period, or are there elements to that program?
There are,
Right now, and we are very grateful to Cook County Probation, is successfully completing the conditions of probation that are set, which normally are set pursuant to assessments and evaluations. What they're hoping to do is to actually develop and create a curriculum for this particular group. So
there's
you
no,
know,
there's not a.
correct.
there are
Stay out of
certain
trouble.
specific requirements in the statute, for example, 50 hours of community service. Because if you look at regular probation, it's usually not 50. So there are some.
I'm looking more so at targeted stuff to
Yeah.
address why did you have a
The
gun?
criminal
That, yeah.
activity, there's
And
the
if
trauma
you have another
recovery.
gun, this is what's gonna happen to you. That, you know, because if we're just, you know, just don't get caught within this period, we're not, that's not addressing the issue.
I would say that our last SPAC meeting, we had the panel, young men who had mandatory sentence. Their sentiment was that we possibly will carry the public safety in our community of undressed life. So how do we balance the individual criteria of we want you in a program, right, with the realization of the carrying gun and state of justice. And many of them, I think this was probably their second stint.
Yes, they were repeat offenders.
And so they were kind of like, we will try to do our best, but
These guys were in jail.
But they
We were in jail with them.
the
Right.
reality is,
Yeah.
the gun makes us feel safe. We're not using it, and we know there's a mandatory out there, but that won't prevent us.
You might have to come back.
And they would be to me, they would be the source of creating that curriculum. Because they would then give insight on, okay, what can we do to help with that? So that maybe you won't, you know, you might, but to lessen the likelihood that it's not so much a norm. So they would be that source to, you know, they're the ones out there in, instead of people who were, you know, from academia who are trying to figure out.
Right, right. And, you know, they also, all three of them, the guns were found in their cars pursuant to a traffic stop. They weren't committing a gun crime per se. So, I mean, I think this, you know, as serious and sad of a context of all of this, you know, it really gives us insight that there are a lot of ways to end up with a gun charge that don't require you to be using a gun, threatening, displaying a gun. There is, as there always is, a small group of those people who are not in that category, which are the people who were, you know, targeted in the Safe Neighborhoods Act. But we have for years talked about programs, talked about violence prevention, talked about interrupting, and the problems persist. So there are so many things that we haven't been able to figure out just by looking at the data. There's more to be learned. That segues into qualitative, but I don't want to cut off the discussion here.
Yeah, I just want to point out, I'm all for better data collection. I don't want to see it bogged down, there's a problem with collecting data, there's a problem with the program. If you can go back to that line graph, there's something that I think a takeaway we should take from this. If you actually extend that graph back before 2012, the red line would be back down where it is now. It actually popped up in 2011 when the UW became compilation. And Cook County that looks different than everybody else for your tenure here. Then this law went into effect and it dropped back down to look much more similar to the rest of the state. So the import of the first time felon program is that drop in Cook County puts Cook County back in line with the way the rest of the state treats UUW. And to piggyback from John's presentation too, that's when the number of UUW arrests was going to increase, right? Cook County maintained this level of use in prison despite a huge spike in UUW arrests. As far as having incredible benefit to the county. Although we can't identify perhaps everybody who went through it accurately. The effect is real, and we can see it already in just that single graph. And I just want to say, it undoes like a 10-year period of the county when the county sentence is quite different than the rest of the state around this particular.
So we need to extend our graph in our report.
Well, yeah.
So yeah, I mean, we do the best we can with the data that's collected, but it's also data that is operational. It's not really here to research, and there might be opportunities to improve that too.
Well, before we go on to the next topic, I'm wondering if this, since they just extended this law for another year, what conclusions could we draw from whether it worked or not? So it seems to me like, remember, Kwame was in charge of this. I was in the legislature at the time. So there was this push to raise penalties because of the increase in gun crime in Chicago. Manuel's the mayor. It sounds like a deal. First time weapon offenders, let's give them a break, right? Bad guys got no warrant. With this data, people say that's what happened.
I do have a question. So are we looking at the recidivism? So are we looking to really see if it
You
worked?
speak up, Christoph.
To see if it really worked. What happens? Like, are these people in the program, are they coming back?
Yeah.
How many times are they coming back?
So there are a couple issues with that. First of all, is we do not have enough data to identify who successfully completes and who does not. It is not consistently reported. When it is, there are some similar issues with the translating between Cook County and the ADR as to whether or not it was successfully completed or just it ended. So we are unable to figure out that. That in turn, that also contributes to the question of, are they coming back? Who is coming back? The other thing is that it hasn't been in effect for very long. These are only 18 to 20-year-olds. And even with COVID happening, things went down a lot. So we don't have a very long-term view to be able to see what kind of longer-term impact on, are those people coming back? It just hasn't been a very long time to be able to tell if that's the case.
Very.
Yeah, I'll talk to you afterwards about individuals. Is anyone working actively to take those individuals whose cases were reported and actually, we're not talking about 10,000.
Yes.
You know,
Thanks to the probation data, the list has been prepared, and they, the last conversation included somebody from ISP, I think, who was talking about how they could do it within CRI, without having to have a form on each case and stuff. So yes, those discussions are underway.
Yeah, I participated with the county stakeholders probably 3 or 4 weeks ago, where they were having this conversation, all over, Chief Judge Evans and Jerome and Clerk subpoenas, they were all
Yeah.
there.
Can
and
we
there
see,
was
can we see who's on?
unanimous agreements to work together to identify what systems we've identified. Because even that was a challenge of
Yes.
who actually got it, so how do we follow
Yeah.
up and know if which one was recorded correctly, because some were recorded correctly. And
Right.
some were not.
All the ones that we currently have in the system were not originally recorded correctly. They were fixed.
But some of them have been corrected.
Yes, they have been corrected, but
In that
Yeah.
way, the system, responded appropriately. But, we have 102 counties, we have a lot of different systems. Again, I'm gonna go back to supporting the ability to analyze the data and also audit it, which there's CJA has that responsibility, but resources need to be devoted to those things. So I don't want anybody to walk away from this meeting thinking that it's going to be a persistent process or a persistent problem into the future, because there's a lot of focus on making it right and correcting the past mistakes.
How are we and how can we legally looking at the juvenile justice system when it comes to this? I mean, we're talking about 18 to 20-year-olds. Our biggest headache are kids, that juvenile, our gun problems on a regular basis are juveniles. So while it might be somebody's first time as an adult getting a gun charge, they probably, I don't say probably, there are many young people who have been carrying and doing things with guns long before they got to 18.
Yeah.
And that comes back to my original statement about, I'm not talking about the incarceration, I'm talking about providing resources to try to stop that cycle. And, juveniles are near and dear to me. And as chairman of the International Chiefs Juvenile Justice and Child Protection Commission, one of the guys shared with me an analogy where there's a picture of a stream. There's kids in the stream, and folks may have heard this before, but at the end of the stream is a waterfall. And there's folks out there, all of us sitting at this table, wading out into the water, trying to pull these kids out of the water before they go over this waterfall. And then there's one guy who goes walking, and people are yelling at him, "Hey, we need all the help we can get. Why are you going upstream?" He said, "I'm trying to find out who's throwing them in the stream." We're focusing on pulling them out. Somebody needs to stop them from going in the first place. So that's what I mean with that. People absolutely need to be held accountable, but at the same time, for those that we can, we need to be trying to provide resources that will stop that behavior and give them that option, so that the only option is not that, hey, that's just how it is, I got to carry a gun. That we teach them otherwise, that it might not be.
Well, I will say the evangelistic plan about that number. Providing prevention, we are doing a better job of finding at-risk populations, which is the key difference in how providers reach those community youth that you're describing, right? $4 or $5 million in one youth development. Every kid needs activities to keep them engaged, and we were missing the mark and going deep and pulling out and acknowledging those youth that would have a lot of social indicators that be our next shooter under the care. So as a body, city, county, state, we're working together to define that we want programs to do. Formally justice involved those highly at-risk youth, which is making a real big difference on who providers recruit into their programs, right? They're not just kind of cherry picking or getting the kids when they're in the program, they're literally going deeper and engaging those street corner kids, those formerly gang involved kids. I think over time we're going to see the impact of making that difference in service.
Okay, Kathy, we want to move on to the next topic?
Right, so obviously the nature of the discussion here demonstrates that there are, deeper questions around how policies get implemented, why they get implemented. And the question I think, that I always kind of come back to is, what do we really want to know? 12 years into SPAC, we still don't have a lot of answers. We have a lot of graphs, we have a lot of fiscal impact analysis, but we've kind of internally as a team been talking about what should we think about, how should we think about potentially integrating more qualitative research into what we do, because hard numbers are wonderful for showing us things and teaching us things, but they don't really move the needle a lot on our hard numbers didn't convince the two Democrats who thought we were despicable that the DOC population wasn't going to blow up with a targeted increase in that one sentence. So, the Safe Neighborhood Act, it requires us to report the total number of persons sentenced under the new provision. It requires us to report the total number of departures, okay? And then analysis and trends in sentencing. So, so what? What does that really tell us? So when we thought about it, we thought about putting in front of you guys the idea of increasing our qualitative capacity, and kind of gone into it a little bit in our next SPAC meetings. Doug Reese mentioned the agreements, and we were sharing it. Hearing from them what their life experience was. Having one fellow say, I got my first gun when I was 12 or 13, and I don't remember how I got it. Everybody had it. I had one too. That's some information that maybe changes our understanding of what policy needs to do. We also had a restorative justice meeting where, we heard from women who were involved with state's attorney's offices who were doing restorative justice and what they witnessed in the experience of victims of the system when they were allowed to have that. And also a person who had been in prison for a very long time because he murdered a teenager his own age, and what it was like for him to be sitting down with the family of his victim and what that offered that was not something currently available in our system. And then way further back than that, we had our violent crime meeting, and we heard from Commander Cato, who's now the Chief of Homeland Security. I can't remember what else the title is here at the CPT, but he had been in one of the more violent districts. And we also had a Sergeant, Jermaine Harris, who's a community police officer, who basically were like, sentencing doesn't have any impact on what we see on the streets because nobody knows about it, nobody cares about it. So we put, we also had two men who had committed murder talking about basically how personal crime is and what led them to change versus what they experienced as a sentence. So we've kind of touched on it in a couple of meetings. We've seen in the policy arena, the Alliance for Safety and Justice came in during the Ronner Commission and did really significant qualitative work with victims of violent crime, surveys and focus groups that fleshed out what victims were looking for and how they felt about the sentencing system. So we kind of have dipped our toe in the qualitative pool because we are currently in partnership with the University of Illinois in Chicago through Catherine Bocanegra, doing a project where she is researching the impact on the individuals who serve long-term sentences on their reintegration into society, how that impacts them, which is obviously contributing to an outcome, a sentencing outcome. So we had a really, we talked about it a couple of times internally. Is this research that has value to SPAC's work? Is this something that we can find useful going forward? Is it something that brings a deeper understanding of outcomes? And we decided that, yeah, we thought we should partner with her on this. And so we went ahead and moved forward with that project, but we also felt it really important to bring the question to you guys and talk through a little bit about, your thoughts and concerns about doing it, how we might want to think about a process to choose projects or develop projects, and, you know, an overall kind of approach if we want to bring this capacity in, because it will require, you know, some additional resources, some research skills that we currently don't have. But I think it might be something that allows us to kind of have a greater impact in the policy arena. And we have, I don't know if Kiara Eckhart is on the Zoom, but she is a fellow from Illinois State University, the Stevenson Center, and she is assigned to that project and is doing work with Catherine. So that's kind of the overview, why we think it's important to talk about it, possibly get into it. And I'm going to let Mark kind of give a little bit more detailed research perspective. And Dawn, I hate to put you on the spot, but would love to hear what you have to tell us from your plea bargaining, which is a melding of qualitative and quantitative, right? So, Mark, take it away, wherever you are.
Sure. So actually, we do have a question. You want to do that first?
Oh, do we have any question?
It'll mesh into the discussion.
So with sensing research, the majority of the research by far is using quantitative approaches and typically administrative data. And for us, administrative data that we have access to is the CRI data, which are Illinois State Police arrests, convictions, dispositions, and so forth. We have access to some clerk data, and then we also have access to the Department of Corrections data. That's all administratively produced data. It's not really intended for research purposes, and it should. And typically, the thing about administrative data is it kind of really covers facts, decisions, and endpoints. We really don't know from that data the hows and whys. So for example, with arrests, we know what people are being charged with, we know what people being charged, but we don't really know how that arrest initiated. Was it a traffic stop, something like that? It's just really not always available in our data. Filings, we would know the charges added and dropped, but we don't really know anything about the processes of those decisions about how they actually add or drop charges. In some jurisdictions, you'll see that they charge several different charges, just keep one conviction, and in others, it's just charge once, you convict once on one single charge. And then things like dispositions and sentences, we know the type of sentence, we know the length of the sentence, but we don't know how that sentence was decided on. We don't know why a judge or a prosecution and defense pair said, let's go 5 years versus 4 years. We don't really have that data. And we also don't even know if the judge was, how involved the judge was in that decision itself. These are all things that are missing. These are the hows and whys that we just don't see in the administrative data. And that's just basically because the nature of that data was not really meant to record that. There are some examples, though, in sentencing research that just highlights some of the things that we could look into. As Kathy mentioned, Donna and a team looked into plea bargaining and disparities in, I think, St. Louis and Milwaukee. And it really kind of shed light on the actual administrative data, the counts of why numbers were higher in certain jurisdictions than others. Florida, there was research recently on prosecutorial reform, basically seeing that what they really saw is that line staff were not really aligned with the actual leadership. And so certain implementations just did not really work out very well. And then also another example would be in Michigan, there was pretty good research on the judges' perspectives on sentencing and convictions. And that really actually showed some things that we could actually benefit from, because they were able to figure out why, for example, habitual criminal enhancements were often added. Typically, they would be added if they decided not to plead. Whereas if they actually pled, there was no habitual criminal enhancements. Those are types of things that we could look into. We really just haven't, because we really haven't taken much of a qualitative approach to our research. Actually, even just on the stuff that we presented today, there's certain things that we certainly could have benefited from. For example, the requirements, SPAC was only required to report on the deterrence effect of the actual UW's minimum, presumptive minimum sentences. But based off of our discussions with the incarcerated individuals in Sheridan, you can kind of tell that there really was not much deterrence effect for them. And just looking at the arrest trends, it doesn't look like there's all of a sudden a shortage of people carrying guns in Chicago. And the other thing that we could have also benefited from with a qualitative approach is the first-time weapons offender program. We know where the counties are that are using it from the administrative data that we have, but we don't really know why certain counties are using it to the extent that we are versus other counties not using it. There's one particular small county that is using it quite a bit more than what we would expect, and we have no idea why. So these are the types of things that I think if we really try to incorporate more qualitative research into our methodology, we could benefit, probably provide a more comprehensive understanding of why the sentencing is actually occurring as it is.
And I think that then gives I would hope, for policymakers, a little bit stronger basis to determine what good policy would look like if they want to effectuate a certain program. So, that's kind of what we're thinking.